Hi, I'm Nick Esterbauer.
And I am Tsvetomira Niklin.
Welcome to How on Estates. You are listening to episode number 638. Today we'll be discussing electronic wills. Hi, Tsvetomira, how are you doing today?
Hi, Nick. I'm very well. How are you?
I'm doing well, thanks. It's nice to podcast with you. This is a first for us.
Yeah, and it's the very first one for me overall, so very excited. Thrilled
Exciting
to be doing
times. That's great.
Yeah.
So Tsvetomira, you brought to my attention last week this recent decision out of the Quebec Court of Appeal that got us thinking about the concept of electronic wills, what's acceptable in different provinces. And I was hoping you might be able to start us off just with a brief description of what happened there.
Yeah, of course. So this is a case, as you mentioned, coming out of Quebec. It's called Damary versus Bitton. And the facts of the case are actually very simple. It's not a complicated case, but it's very thought-provoking, and it makes you think about the different laws that are throughout Canada and the lack of uniformity, rather. So the facts of the case, as I mentioned, are so simple. So Mr. Bitton actually had prepared a will in 1989, which is a will that he executed in front of two witnesses, and it was the most basic form of will that you can ever imagine. Unfortunately, Mr. Bitton, around 2020, decided that he wanted to revise his will. And he did this while at the hospital, unfortunately, when he was hospitalized with COVID-19. So he didn't have time to formally execute his will. However, he submitted his draft will to his notary, and he said, "These are the provisions of my will, and I hope that you'll be able to sign me, but if not, then this is my signature." So all this was done via email. Now, within the next few days, Mr. Bitton passed away, and he was unable to formally execute his will. Thereafter, now we have two wills, one which was a very formally valid will, and another will which was an electronically signed will. So when it came to probating his will, his children, Mr. Bitton's children, sought to probate the 1989 will, whereas his second spouse sought to probate his 2020 will, wherein she was inheriting more, and in the first one, she was inheriting nil. And the court held that the will executed by email was not a valid will in the province of Quebec, and therefore they probated the 1989 will, and this was the decision that was upheld in the Court of Appeal of Quebec.
Great, thanks, Esterbauer. So yeah, it seems like a fairly straightforward situation here. It's actually not all that unlike one that we saw in British Columbia a few months ago. And these were nice, concise reasons that we'll provide a link to them in the description for today's podcast. But I like how the court even takes a look at sort of the convenience factor, especially during times like COVID pandemic when people are under a lockdown, and then the technical requirements that you need to comply with. And the court said there is no doubt that restrictions imposed as a result of the COVID-19 pandemic create unique challenges in regards to the formalities that must be respected in order for a will to be considered valid. So here, in reviewing all the evidence, there just was not a basis to, declare that in Quebec, where there is, I believe, substantial compliance, this was not substantially compliant with the requirements for a valid will because it simply wasn't signed. And during the pandemic, as many of our regular listeners will know, we have seen new opportunities in terms of remote execution requirements, which have recently been made permanent in Ontario. So we're now able to make those arrangements to sign and have witnessed a valid will without meeting in person, to make things a bit easier during COVID when it's been impractical or possibly dangerous to meet in person.
Yeah, I think it's been really nice, the changes we've seen. However, for example, in Quebec, they mentioned they have testamentary formalism, which requires very strict adherence to the rules. So I think it's neither here nor there, because we have these options of, hey, you can do it remotely, but then in Quebec, they're saying, well, no, you must do it this way. So in light of the COVID-19 restrictions, it's definitely been a step forward, I think, from stepping away of these extremely formal rules. And we're seeing how we can actually be doing things in a more easier way and still maintain the formality.
For sure. So moving on, Mira, we've got, as of January 1st, 2022, so still very recent, and still we're learning exactly what it means and how it's going to be interpreted by the courts. But we have a new validation clause, will validation clause in the Succession Law Reform Act. section 21.1. I'm wondering if you could please review that for us.
Yeah, of course. And in fact, it's so new that in preparing for this podcast, I actually tried seeing if there's been any recent decisions with respect to section 21.1 yet. And there haven't been, but it's a really exciting time to see how the courts will treat it. So in the oncoming weeks, we'll see if there's any decisions that come out. But essentially, section 21.1 is court ordered validity, which provides that the court can essentially cure a will. So where a will is not executed in the most proper way possible, the court can look at it and see if there's testamentary intention of the deceased to either amend his will, revoke a prior will, or revive a will. However, one interesting provision of this section is that it does not apply to electronic wills. So in the case of Mr. Bitton, that would not have applied.
Right. So in Ontario, even with this change, even with this new validation provision under the SLRA, we still don't have the option of using digital signatures, digital wills. We, at least for the time being, probably won't be seeing anything like the situation in Quebec being upheld as a valid will, because we still need to be signing a hard copy document. Even though I know there's been some discussion in recent years, we may have sufficient safeguards in place to make digital will execution an option that may work. And it's actually something that's now being seen in British Columbia. Do you mind updating us on what's going on there?
So in British Columbia, as of 2021, you are in fact allowed to have digital wills. And they've done a very good job laying out what a digital will is and knowing what a digital signature is and what is acceptable. And that is found in the Wills and Estates and Succession Amendment Act, WESA. And essentially, it's well described in section 37, but in the previous section of that as well. And you are allowed to essentially have an electronic will where you've never really met the people in person and it is entirely executed online.
So we're seeing different options in different provinces. And I mean, state legislation is provincially based. So we do see different things happening in Ontario and Quebec and British Columbia, and it'll be interesting to see how our law here may develop over time based on what's happening elsewhere.
Yeah, I think British Columbia is a really nice, see how it goes. And maybe we'll adopt similar provisions. I mean, the SLRA updates from this year are kind of getting there. Now that you can witness wills virtually, there's really no reason why in the upcoming years, so long as it goes well in British Columbia, we won't say, hey, that's working out for them, so why not us too?
Great. Well, I think that concludes our podcast, Mira. So until next time, we want to thank you for listening. I'm Nick Esterbauer.
And I am Tsvetomira Niklin.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website. Thanks very much.